Good morning, everybody, and welcome to the second meeting of the Farm and Forest Improvements Rules Advisory Committee meeting. So let's see, it's a little bit after 9, and I think we have most folks on now. But this morning, we are going to start off spending a few minutes on introductions, and then I'm going to take a moment to review our charge to reorient us to the goal for this meeting and for this rulemaking in general. And then this morning, we're going to be discussing two standards associated with the general agritourism and other commercial events opportunities, and also the application of the farm impacts test to rural transportation uses. Right. And for this meeting, I do want to leave a little extra time at the end of the meeting to talk about and to answer any questions on the next steps, which will be heavily influenced by the upcoming Land Conservation and Development Commission meeting that's later this week. All right, so why don't we go ahead and start off with introductions. We have a really great group here, and the feedback from this group, the substantial feedback from this group has already been super informative. So for folks I don't know, I'm Hillary Foote, and I am the current Farm and Forest Specialist for the Department of Land Conservation and Development. And I'm going to be supporting this Rules Advisory Committee over the next several months. So I also wanted to introduce other key DLCD staff who are supporting this process. So also with us this morning is Casaria Taylor. Casaria, do you want to introduce yourself?
Hi, good morning. My name is Casaria Taylor, and I'm the Rules Coordinator supporting this project.
And so if you have any technical questions, please reach out to Casaria if you're having difficulty raising your hand or, getting something into the chat or with Zoom links or other things like that. Go ahead and send a little note to Casaria. Also with us, I believe we have Gordon Howard, who is the Community Services Division Manager for the Department of Land Conservation and Development. Gordon, are you on this?
Thanks. Yes, I am. Hello, everyone. Gordon Howard, and welcome to all of you for our second meeting. And presuming the commission adopts our proposed additions at its April meeting coming up later this week, we'll be having a couple more meetings on some additional issues, perhaps returning to look at some of the issues if there's more time needed. So welcome everyone, and looking forward to this discussion today.
Thank you. And also with us, we have our LCDC liaison, Commissioner Barbara Boyer.
Good morning, everybody. Thanks so much for being here today. I am Barbara Boyer. I'm a farmer out of Yamhill County, and I represent Willamette Valley on LCDC. And I am here to listen and learn from you all. So thank you.
So now I'm going to go ahead and go through introductions alphabetically by first name. And when I call your name, I'm going to ask you to introduce yourself, your organization, if you're representing an organization, and briefly share a little bit about what a successful meeting today on these topics would look like for you. So that means Alyssa Bowles is up first. Is Alyssa with us this morning?
Yes, good morning. Alyssa Bowles. I'm with the Linn County Planning and Building Department. I'm their planning manager. A successful meeting today would be kind of similar to the last meeting, good discussion, kind of covering the topics and so letting everybody have a chance to talk.
Great, thanks, Alyssa. So next would be Amber Bell.
Good morning, I'm Amber Bell. I'm the planning director with Linn County. I'll just echo what Alyssa has already said about the meeting today. I look forward to hearing the other RAC members' perspectives and being able to cover each topic and go through and anyone who has comments be able to share those.
Okay, thank you, Amber. And next is Austin Barnes with Marion.
Hey guys, Austin Barnes, Principal Planner with Marion County. Really enjoyed our last discussion and looking forward to hearing more about what everyone, especially from different parts of the state, have to say about how they interpret the rules and apply them. Find that really, really interesting and engaging. Thanks.
Great. Thanks, Austin. And Blair Batson.
Hi, I'm Blair Batson. I'm a staff attorney with 1000 Friends of Oregon. And I think a successful meeting was demonstrated with our last meeting when everyone got to speak and Hillary was able to keep us all on task, which is challenging with a group like this. So a repeat of last time's performance would be great.
All right. Thanks, Blair. And Charles.
Hi, Charles Bennett, Jackson County Planner here. I would echo what Blair said. I appreciate what she said there, but maybe we add on to that for a successful meeting. Are we going to maybe get some consensus on what happened last meeting? I think that's probably on the agenda, is kind of wrapping up that maybe, or at least getting some more direction on the conclusions and discussion we had in the first meeting. So I'd like to see that.
Yeah, thanks, Charles. And I will touch on that a little bit before we get started with our substantive conversation today. Also, today we have a new member joining us. So Elaine Albrecht is with us today as well for Wine Growers.
Good morning. Thanks, Hillary. I'm Elaine Albrecht. I'm a land use and permitting partner at Davis Strait Tremaine. And I'm on the rack today representing the Oregon Wine Growers Association. I'm looking forward just to getting caught up this is my first meeting. So hearing about the first meeting and also appreciate the open conversation and open minds. So thanks for having me.
Great. Thank you. And welcome. All right. And next we have Jim Johnson.
Hi, everyone. Jim Johnson, Oregon Department of Agriculture. Boy, everything's been said. I guess I would agree with what Blair said. The last meeting went really well and was well structured and everybody participated. I'd just like to see a continuation of where we're going. Thanks a lot.
Great. Thanks, Jim. Also, we have Jan Lee today.
Yes, I'm Jan Lee from the Oregon Association of Conservation Districts, our 45 districts around the state. And I'm hoping that we continue to have the kind of consensus that we've developed and to come out with an end product. Thank you.
All right. Thanks, Jan. And we also have Jeff Kleinman with us this morning.
Good morning, Hillary.
Good morning.
I'm a lawyer in private practice in Portland, and I thought, as I said at the close of the last meeting, it went really, really well, and look forward to a little bit of refinement on issues and language.
Great. Thanks, Jeff. And Justin Green.
Good morning, Justin Green Consulting. I used to work for the Florida Department of Environmental Protection and the Oregon Department of Environmental Quality. Yeah, I really enjoyed the last meeting. I thought it was really good communications and conversations, and I really appreciated the focus on kind of the real life implications and implementation of our conversation. You know, what it would be like for someone to implement these rules in making decisions. I've recently gone through a land use decision, and it was, you know, it's a really interesting process and a really important process. So I really appreciated that focus on the real life implications. Thank you all.
Great. Thank you, Justin. And Catherine Daniels. Oh, you're muted, Catherine.
Hey, I'm Catherine Daniels, former farm and forest land specialist for the department, and I'm looking forward to hearing a wide range of views from a wide range of people.
Great, thank you. And Ken Katzeroff.
Hi, good morning. This is Ken Katzeroff. I'm sorry you don't get to see my pretty face today. My camera's not working for some reason. I appreciate everybody's comments last meeting and so far this meeting and look forward to a continued discussion. Thank you.
All right, thanks, Ken. It took me a while to figure out my new camera this morning as well. So I empathize with that. And Lauren.
Good morning, everyone. Lauren Poor, Oregon Farm Bureau. And I guess a lot of it has been said, but what I'd also really like to see is that the discussion has been reflected in the end result of the rules, that we're not just talking about something that's already been determined.
Thank you. And Maitri?
Hi, I'm Maitri Sinha. I'm the Senior Rural Planner with Washington County, and I'm looking forward to a conversation where everyone is contributing meaningfully and where we're flushing out the issues and covering the topics that we have planned for today. And thank you for holding all of this together so well, Hillary.
Thank you. All right, and we have Megan.
Good morning. I'm Megan Dovchevsky from Umatilla County, and I'm the planning manager over here. I agree with what's already been said, that the last meeting was really successful, so just a continuation of that. And I think Hillary and the others did a really good job of allowing everybody to share their thoughts. So thank you.
Great. And Mike McCarthy.
Yeah, Mike McCarthy, McCarthy Family Farm in Parkdale. I'm a first generation farmer, make 100% of my income from farming. I also represent Ag for Oregon, which is a new farmer rancher land use group.
All right, thank you and welcome, Mike. And is Nikki with us this morning?
Good morning, Hillary and everybody.
Morning.
Yep, I may be in and out. I have a ewe that has tips of 2 hooves out, so that's more priority. Just I would like to see the outcome that the ewe has healthy babies and that we continue after the first meeting. I was impressed with the way it was ran and with everybody's thought process and willing to work with everybody. Hopefully we'll finish on time.
Right, thank you. I also hope the birth will go smoothly. All right, Nellie.
Hi, everybody. Nellie McAdams with Oregon Agricultural Trust. And I agree with what all's been said. I just add that I hope that DLCD gets all the information that you need from us in order to make those rule changes. So thank you so much, Hillary and everybody.
Great. And Rob Halliburton.
Hi, I'm Rob Halliburton with Friends of Yamhill County. I pretty much agree with what others have said about the meeting.
Great, thanks. Good to have you this morning. And Rory.
Yeah, good morning, Hillary. Good morning, everyone. Yeah, I'll also agree with what's been said. I hope we have good discussion and consensus on interpreting this case law to create some good rule amendments for uniformity and how they're applied across the state. And yeah, also hope that Mickey's ewe has a successful delivery this morning. That's a new goal for this meeting.
We'll be looking forward to the updates, Mickey. Samantha. Is Samantha with us this morning, Casaria? No?
I see her in the participants. She appears to be unmuted. Let me see if I can chat with her and help her out.
Okay, great. Thanks, Casaria. And is Tyler Ernst with us this morning?
Yes, I am Hillary.
Great.
And, like Ken, a non-functional camera, so I apologize for being off camera. Tyler Ernst, I am General Counsel and Director of Regulatory Affairs with the Oregon Forest Industries Council. I was unfortunately absent for the first RAC meeting, and so personally, one of my goals for this meeting is just to kind of get up to speed with what happened from last meeting.
Great. Well, we're welcome, and we're glad to have you with us this morning. And I realized, I'm so sorry, Joy, I skipped over you.
No worries at all. Can you guys hear me today?
Yeah.
Okay. Hi, everyone. Joy Levitt with the Oregon Department of Fish and Wildlife. I am the state land use coordinator, and I missed the first meeting. So I think to echo, I'm looking forward to just kind of being part of the discussion today and hearing what you all have to say and learn from you all. And I think, yeah, just I think, Hillary, you do a great job facilitating, but just to, a good goal of the meeting, I think, is just, having everyone be open to find common ground and listen to each other. I think that's always a good goal, but nice to meet you all, and thanks.
Great. And Samantha, were we able to work out those issues? Just want to make sure we
She's having technical issues. She's going to try restarting her computer and coming back to us.
Okay, great. So we also have Samantha there with the Property Owners Association on our Rules Advisory Committee, and hope that we'll get her back in here in a minute. But we have a really great group here representing a variety of perspectives on these topics. And, you know, as I mentioned earlier, I appreciate all of the feedback that we've gotten so far from folks. And I just want to reiterate that all of you were asked to participate in this advisory committee because we do want to hear from you. So if something occurs to you after the meeting, or perhaps you don't feel comfortable speaking up about something during the meeting, we do want to hear from you. So please feel free to forward me your thoughts or schedule a call with me. We did get a lot of written feedback after our first meeting on the farm impacts test and the commercial activities in conjunction with farm use topics, as well as edits to the meeting note. And so that has been super helpful. And thank you to all the folks who took the time to do that. All of those comments, all of that feedback is posted on our website and is in the packet for this meeting. So everybody also has access to those comments that have been given to the department. And if anybody wasn't able, for some reason over the past couple of weeks, to get comments or clarifications into us on the farm impacts or commercial activities in conjunction with farm use topics and discussions, and you still want to do that, please go ahead and send us your thoughts. And, you know, we will consider those and they'll go into the next meeting packet. So I do want to encourage that sort of ongoing collection of feedback. And I do also want to let folks know that it is our intention to carefully consider all of these comments that we are collecting as we are working on, you know, the proposed rule language. It's our intention that at our July meeting, we will have a discussion on the agency proposed revisions to the draft rule language. And we will get that, you know, language out to you many weeks in advance of that meeting so you can review and comment on it. And there will be additional discussion on that in July. And, you know, I do want to reiterate, this came up a couple of times, that while it would be really fantastic if we all came to a consensus, you know, on the language on these topics, we don't necessarily have to. And if there are alternative perspectives in the group, we will note those in our report to the Land Conservation Development Commission. And of course, all of you have the right as members of the public to participate in the LCDC hearings, which will be in September. Whether you want to support staff's recommendation or whether you would prefer, you know, to see something else in the real language. So Gordon, did you want to add anything on to that before I sort of move on into the substance for today on the schedule?
No, the one thing I did mention is that once again the commission is considering a proposal to add some additional matter for consideration by the Rulemaking Advisory Committee, and we'd be scheduling, you know, additional meetings and have additional topics going forward to the commission at September. And I would point out also that the commission meeting in September is the first of two on this topic. They would not be adopting rules at that meeting. They would be considering them for the first time, and then they would have it back on their agenda at their December meeting for potential adoption at that point.
Yeah, and I was planning on leaving a few minutes at the end of the conversation today to just go over briefly the topics that, you know, LCDC will be considering on Thursday and answering any question that this Rules Advisory Committee might have about expanding the charge.
And one other point, Hillary, is that any new topics would be considered by this same rulemaking advisory. We would not be trying to formulate a new one at that point. This is things went so well last time, and we expect them to continue to go well, and we look forward to working with you as a group.
Yes, agreed. All right, so just before we move into the discussions this morning, I just wanted to really briefly revisit what it is that LCDC has asked us to do. So they've asked us to come up with some new rule language that codifies some identified case law standards that will result in more consistent implementation of those identified standards across Oregon counties. And that will provide additional clarity to counties, rural residents, and potential applicants with the intent of reducing unnecessary appeals. So as we talk about the DiBenediti case today that took up the two standards related to agritourism and other commercial events, and as we talk about our rules on transportation uses on rural lands, I just ask you to keep this direction in mind. All right, so let's go ahead and move right into our first topic today. All right. So our first topic this morning, and we have probably about an hour and 15 minutes on this topic, hour and a half maybe. We'll see where we end up, but we're going to be talking about two standards that apply to the agritourism and other commercial events use at 215.213 sub 11 and 215.283 sub 4. So the rule language we're looking at is specific to these opportunities. So let's talk about that a little bit before we move into the DiBenediti language. So agritourism and other commercial events, this use is a fairly recent addition to statute. It was added to Chapter 215 in 2011 by Senate Bill 960. This language is optional for counties to adopt, and a little less than 2/3 of Oregon counties now offer general agritourism and other commercial event opportunities in their codes. So there are a few counties in the state who have chosen not to offer this use. And I think one of the counties that we have on our advisory committee doesn't offer this as an opportunity, but I'd be curious about that. So some counties have adopted these provisions and some haven't. So under 215.213 sub 11 and 215.283 sub 4, there are 4 levels of events that are permissible. There's an opportunity for a single event permit. There's an opportunity for an expedited small event permit. There's a permit for up to 6 events per year and another permit for up to 18 events per year. And all of these opportunities, all of these levels, if you will, have slightly different sets of standards that are associated with them. All right. But one of the standards that is common to all of the event levels that may be permitted under this category is that they must be related to and supportive of agriculture, and that they must be incidental and subordinate to an existing farm use on the tract. So a tract is contiguous properties under the same ownership. For the opportunity for up to 18 events per year, there is also an additional standard, and a county must find that the events are necessary to support commercial farm uses or commercial agricultural enterprises in the area. So both of the standards were discussed in the DiBenediti case. And that case involved an application for up to 18 events per year. So the subject of that case was the sub D on this chart here, the agritourism provisions that were in 215.283 sub 4 sub D. All right. So as a planning department is considering these types of applications, it has to answer the question of what it means to be incidental to an existing farm use, what it means to be subordinate to a farm use. And this really is a term of art that comes up often in planning conversations. So I thought maybe I would ask Charles to kick us off with some thoughts on this as a county planner. And I know, Charles, that you had some suggested revisions to the language too. So maybe you could share your thoughts about how you approach gathering evidence to satisfy those conditions and what your thoughts on the language were.
Okay, thank you. We're one of the counties that hasn't adopted this language. We were going through the process in 2019 through a large farm and forest revision to add a lot of information, details that we went through the planning commission, went as far as that, and then we had some issues and we haven't picked it up again since then. So yeah, we're one of the counties that doesn't implement this at the moment. I just was I don't know what exactly. I mean, I think the revisions I submitted were really just to reflect more of what was in the circuit court appeals language. I thought the recommended language that you have just had a little bit of ambiguity as far as I thought the way the predominant farm use on the tract could sidetrack the issue of focusing, because there could be multiple farm uses on a tract, and so that this rule doesn't apply just to the predominant one on the tract, and as well as the commercial agricultural enterprises in the area. I was a little concerned that if you, let's say you wanted a 420 event and you were going to support the marijuana farm use in the area, you have but you don't have a farm use on that property, you could use this rule to say that because you're supporting the commercial agricultural enterprises in the area, that it's sidetracked from what the actual ORS mentioned. So I don't know if I guess not everybody has seen the comments I submitted to Hillary, I imagine. So, but I just again was reflecting what was in the ORS and the OAR. But I don't think I answered your question, but
no, that's great, Charles. I called on you first because you did submit comments. So yeah, we have, like last time, received a few comments on Friday and today that will be included sort of in the next circulation, just like we did last time. So what I'm hearing is a little bit of concern that there may be multiple farm uses on the tract, and that they should be all considered in addressing the incidental and subordinate standard, not just the predominant farm use on the tract. And perhaps a clarification in addition to what is in standard, that farm use must be occurring on the tract or the properties that comprise the farm operation. Jeff, I think you had a comment that was somewhat similar. Did you want to share sort of your thoughts on that topic?
Yeah, thank you. I spotted the same issue that Charles did and submitted some language that moves the word predominant around. And I think solves the problem of, it's pretty common that there be multiple farm uses, especially in the Willamette Valley. So I think that takes care of that. And in the same way, it also makes it clear that after the approval under these standards, that the farm use, and that means the collective farm use on the tract, remain predominant, not be abandoned, in other words. So.
Yes, thank you. So, yep. Again, another request that we redo this language in such a way that it includes all of the farm uses for consideration under the incidental and subordinate standard, not just whatever happens to be the predominant farm use on the property. Elaine, you had a thought on that particular proposal?
Actually, it's more of a question. I'm just having a hard time tracking Charles and Jeffrey's. Are the comments that we're talking about that they submitted in the packet for today?
No, they provided comments on Friday and today. And so
Okay,
there is
so
not
we
time to
have not
circulate them.
seen that language then that you are asking them about.
Yes. Mhm.
Okay, and
So we're
then
collecting general sort of feedbacks on the concepts, and so I'm reiterating what I'm hearing from them as a concern that in a case where multiple farm uses are being conducted on a farm operation, that the incidental and subordinate standard apply to all of the farm uses and not simply the predominant farm use.
that would be a very difficult test to apply. I don't think that I would support that. So I'm having a hard time catching up on where we're going with this, but that seems incredibly burdensome for an opportunity that only occurs up to 18 times per year.
Do you want to talk a little bit more about that? Why you think that would be burdensome to address?
Sure. I just think that this agritourism, pathway is supposed to allow an opportunity for farm operators to host, up to 18 activities per year on their property that provides additional income. And they're already, essentially like safeguards in the statutory language that require it to be incidental and subordinate and necessary to support the ongoing commercial farm operations. Those seem like pretty clear language to apply. And if you're looking at the predominant, I mean, most of the agritourism have to go with like some type of farm festival, some type of gathering around harvest or blossom festival or things like that. And so if you have, I guess we need to look at it as like, does that farm activity rise to the accepted, like where are they generating the income? You may have, it just seems like it's very difficult to do an inventory of all the farm practices and then analyze it against each one, that you could be ending up with 10 different farm practices, and the burden is on the applicant. And so we could be in a situation as an applicant having to defend and carry the burden on this. And I think it's just a huge evidentiary standard that is the legislature did not mean to impose on that farm operator who's trying to supplement their income with these up to 18 events. So I'm happy to provide some more in writing, but that's just kind of the bigger picture thinking about it.
So you're concerned that it might be difficult for an applicant to identify the farm uses that are occurring on their property? And
no, I think they could, but then they're obligated. I mean, they likely can, but then they're obligated to evaluate and demonstrate this, which is being discussed to be a heightened evidentiary standard for each one, rather than just for the main one. So I think it puts a lot more burden on farm operators who are looking to take advantage of this, agritourism pathway to generate additional income. Makes it a lot harder for them to be able to prove up that they're entitled to it.
So do you want to provide an example maybe of that would be helpful? Like, can you think of, say, somebody had a little side egg operation or something like that?
Yeah. So say somebody grows cherries, and they host, harvest, blossom, some other different types of agritourism associated with their cherry farm, but they have a bee business and they also have a farm stand where they sell their eggs and honey, So do I need to analyze? Really, my main business, my farm operation is my cherry farm, but I have bees and chickens that I also sell products from. Do I need to analyze it that my cherry blossom is essential to my bee operation or my chickens?
So that so identifying that the festival is subordinate to the cherry operation, the bee operation, and the egg operation, all of those would be
I'm
be
not worried about
burdensome.
incidental
Okay.
and subordinate. It's the
Mm.
language and part B, you're talking about necessary to support.
The necessary to
being
support.
expanded
Okay.
to being required to be essential in order to maintain. And if then you're saying it's essential in order to maintain all the farm operations on the property, not the predominant one, that's a very high evidentiary standard for a farm operator to meet.
Okay. Mike, did you want to share your thoughts on that topic?
Mine's a technical question. You say we're making an amendment to OAR 13043. I maybe have an old document on 660, but I don't find 42.
I believe there's a 42, but there is no 43. So what we'd be doing is adding a new section to rule.
Okay, I don't see a
Specific to
42, but
this.
maybe there is one. Anyway, thank you.
Our rules coordinator will make sure that we get the numbering right. But thank you for pointing that out. All right. So other planners who do have this opportunity in your counties, how do you go about collecting evidence or walking through an applicant through what they need to do to satisfy an incidental and subordinate standard? I think that would be helpful.
Yeah, I can go. What we do here with Marion County is when people come in for these is I normally use the term or kind of like the phrasing that if this agritourism event wouldn't otherwise happen without the farm use, then it's not agritourism. So for instance, last year I did one for barrel racing for horses, and it is at a farm where she raises and stables horses and does riding lessons. So it's very much in line with that sort of farm use. But then last month we had someone, which ended up being a whole code enforcement thing. They applied for the single day over the counter non-land use decision agritourism permit, and ended up what they wrote down was horse racing and horse showing. But what ended up happening from the reports we got from neighbors, they did go over that person limit. I forget if it's 100 people or 50 vehicles. They went over that limit is one thing. But in addition, what we found out was, well, this was also kind of a Super Bowl party. It happened on Super Bowl Sunday, and they had a big, screen up with the game and drinks and everything. So yes, there was horse showing happening, but the people really came for drinking and Super Bowl parties. So that Super Bowl party can happen without horses any day of the week, but the horse showing and the horse racing is not going to happen unless you're stabling and breeding horses and involved in that sort of operation. So I tell people if it's not already gonna happen without that farm use, it's not really agritourism, and that really helps them kind of frame what I can look at to see what's available to me. And I would add just a note too. I think it is fine to leave the predominant farm use on the track as language because like the person before me was speaking, if you've got 5 different farm uses on a property, but your one use is 80% of your time and your profit, then that's probably what you're going to focus on for agritourism. And I don't think you should have to show how all the other incidental things you do, the other farm uses are going to be supported by that agritourism. If you have one thing that is a farm use on your property that you do want to do an agritourism event for, you can do it for that one use as long as you meet, the code section.
Okay, thank you.
Yeah.
And so, Austin, I'm hearing that you sort of guide your applicants to demonstrate that this event is tied to that farm use. That if they're proposing something that wouldn't happen, that could happen, in absence of the farm use, then that wouldn't qualify under these standards.
Yeah, generally yes.
Okay.
Yeah.
And supportive of keeping the predominant language structure. Charles?
Yes, thank you. I wanted to just point out, so I was referring to the Circuit Court of Appeals language, which, if I may read it real quick, if people don't have it in front of them, it's page 739 of the Circuit Court. It says consideration of any relevant circumstances, including the nature, intensity, and economic value of the respective uses that bear on whether the existing commercial use, farm use, remains the predominant use of the tract. So the predominance is not, it's the farm use that needs to remain predominantly the use. So that may be a combination of farm uses, but it's the overall, that's where the predominance is. And I think the way the language is written here, it's getting that confusion. Is it's not talking about the predominant, what predominant farm use, or there's subordinate farm uses, like if you're growing hay predominantly, and then you want to have some pigs that you want to, I don't know, show pigs or something, and but that's not your predominant farm use. That's not saying you can't have an agritourism event around your pigs. It means that the overall farm use remains predominantly the use, and not, some other commercial use becoming the predominant use of the property. So that's why I'm recommending that circuit court language.
Okay. Thank you for that clarification, Charles. Jim?
Let me unmute myself here. Yeah, I want to think about this a little bit more, but I'm starting to, I have a lot of agreement with what Charles just said. When you look at the definition of farm use in 215-203, it includes a whole range of things, from growing to cultivating to all the different things that you do when you're in farm use. And to me, if somebody's growing 5 different things on their property, it's all farm use. And so you don't base whether it's farm use on the predominance that you're growing beans, but you're also raising some chickens, and you've got cherries and the like. Farm use is everything together that fits within the definition of farm use. I want to think about this some more, but I think Charles is going in the right direction. Having said that, I think Mr. Kleinman's language is actually very good for us to look at as a framework to address this issue, and I'd like to look at that some more also. Thank you.
All right, great. Thank you, Jim. Would it be helpful if we threw that version up so we're all on the same page? Maybe for folks to look at, and I'm trying to not share my email. Here we go. Let's see. Let me just do that. Okay, look at that. So this is the edit. And I think, Jeff, this is what you would propose as an edit, right? Is that a determination that an event or activity is incidental and subordinate requires an inquiry into the relationship between the existing farm use, which must be and remain the predominant use, and the subordinate events use, including factors such as the nature, intensity, and economic value of the respective units. So there we are getting rid of predominant, but referring generally to farm use as a whole, which is defined in statute at 215-203. And so that definition would come to bear. I'll leave that up there for a little bit. And while we're thinking about that, Rob, did you want to add something?
Yes, thanks. I wanted to point out that this isn't just a hypothetical conversation, that there is actually some case law on this. Yeah. It's yet another Friends of Yamhill County versus Yamhill County from last year, where it was very similar to what we were talking about. It was a diversified farm operation, and the county approved events based on just one of the, almost a sideline crop that the farmer was raising. And LUBA found that that the county needed to demonstrate that the events supported the entire commercial farm use, not just one crop, or in this case, livestock that the farmer was raising. and I've got a citation for that case if you want it. But so I agree that with Jeff's language. I would also suggest that on the second line right after Jeff's amendments where it says and the subordinate events use, at the time that a county would be applying these criteria, it hasn't been determined yet whether they are subordinate. So I think using the word subordinate there is wrong. I think it should say the proposed events use.
Mm-hmm. Okay. I see that. Thank you, Rob.
That's what I've got for now.
Okay. So how about some of the other counties, maybe Washington, or Megan, or Lane? How do you work with applicants on, providing evidence to meet these test requirements?
Well, I can go first.
Thanks, Maitri.
So I think Washington County hasn't really adopted the agritourism standards. So we just allow some in conjunction with a winery, but we do often get inquiries about setting up agritourism events and things like that. So there's really very limited options that they have, which would either most of the time fall within that 25% of whatever commercial uses are allowed and things like that, or in conjunction with farm stands or whatever the 18-day we have with the wineries. And so kind of a lot of it is, I guess it doesn't apply in our case. But this is a very interesting discussion, and I kind of tend to support from what I'm hearing that having a mixed farm operation on the property should allow for different types of agritourism options as long as that farm operation actually exists on the property. And I suppose the scale can be varied depending on the scale of the farm operation, like whether your agritourism is for something small like the pigs they mentioned, or something big like cherry picking or something like that. But yeah, I'd probably mull this over some more and send you written comments.
Okay. Thank you, Maitri.
Yeah, thank you.
Alyssa or Megan, do either of you, I don't think that Lynn County actually has this as an opportunity. Do you, Alyssa?
No, we chose not to adopt it. We had discussions with our commissioners back when this passed and they were not interested. And it's come up in recent discussions too, and they're still not interested in adopting it. They thought there it'd be too many issues with potential code enforcement or people not demonstrating there's that need to tie it with the agricultural use of the property.
Okay, thank you. So Mike or Mickey, maybe do you have multiple farm uses happening on your property? And if so, what does that look like? Or do you primarily focus on one single farm use?
I could comment. We grow apples, pears, cherries, and a number of other crops at times, sometimes have cattle and hay. And so we have a number. It wouldn't be particularly challenging, though, for one to get the total income from all different crops. I mean, that's very simple. You press a button in QuickBooks and you get whatever you need to know. So I don't think that's complicated if you have to determine the scale of all the farm uses. That's not complicated. I do have a couple of other comments on this, though. I find it extremely confusing, and I guess the planners do it every day, so maybe they don't, but extremely confusing when you start looking at the agritourism wording in the winery statute and then in 283 and try to figure out which one means which and which one's applicable at which time. And it seems like if we're going to simplify or revise this wording, it ought to somehow be consistent with the wording in the winery statute also. And I don't believe it would be the same. So I think it's very complicated, and anything we can do for clarity would be important. I do, I guess it was Matry just mentioned code enforcement. Maybe it was somebody else, but it was Lynn County. We have a lot of situations where they're out of compliance, and I don't think we're actually dealing with that now, but anything we can do to improve the wording and the clarity around incidental and subordinate and how you calculate that would be very useful, because we have a lot that are out of compliance, and it's very difficult for the county to even start to figure out where they are. And if we remember, the burden of proof is on the applicant. So the applicants do need to go through a number of serious hurdles to prove that it's incidental and subordinate. And I don't think it's particularly complicated to do this, particularly since it's your own farm.
All right, thank you, Mike. So yes, I do want to acknowledge that the winery statutes in 215-452 and 215-453 also include opportunities for events, agritourism events that are specific to wineries. So there is a definition that is unique to those type of events in the winery statutes, and there is a sort of broader broader standards that are associated with those. So for wineries, cideries, and breweries, there are different rules essentially that apply to those agritourism events. So what we're talking about and what the charge from the commission really is limited to this general category of agritourism and other commercial events that is in 215-283 sub 4 and 215-213 sub 11. So our intention really was to focus on this broader category for right now. Let's see, Elaine or Jeff, did you have any other thoughts as folks are talking through this about your concerns for?
Yeah.
Mm-hmm.
I'm happy to provide some more thoughts and circulate to the group, but I think my concern is demonstrating that the agritourism use is essential in order to maintain all the farm uses. So when we're talking about inventorying farm uses, I agree. It's you can inventory the farm uses, you can inventory what money comes from the farm uses, but it's this burden that we're talking about, the standard that this new burden. It's the standard that would apply and the burden the applicant has to carry to demonstrate that a particular agritourism event or other commercial activity is essential, and then you have to apply that essential to each of the farm uses, not just the predominant one.
Mm-hmm. And so I think what you're talking about, and I'll go ahead because I thought it was really useful to have Charles read the quote from the case. So I'll go ahead and do that so we all remember what it said. So the case that we're talking about, the quote that we're talking about that's relevant to the necessary to support standard, and that is the standard that's applicable to a request for 18 events per year. So this is the quote: accordingly, we construe the statute to require that in order to establish that proposed events are necessary to support either the commercial farm uses on the farm or commercial agricultural enterprises in the area, within the meaning of the statute, the county must find that the events are essential in order to maintain the existence of either the commercial farm or the commercial agricultural enterprises in the area.
Right.
Right. So
the commercial farm.
Yeah. So
yeah.
So the necessary to support either the commercial farm uses or on the farm or commercial agricultural enterprises in the area. So the necessary to support applies either to farm uses on the farm or commercial agricultural enterprises in the
Didn't it
area.
say, I guess I don't have the case up in front of me, but
Yeah.
didn't it say the commercial farm enterprise? Like it's, so we can parse language all day.
Yeah.
You get the point though about the policy position.
Yeah. And so what are other folks on thoughts on that particular question?
Samantha. Hi, I've had my hand up for a while, but I want to tack on to what Elaine
I'm
is
sorry.
saying.
Yeah.
No, it's okay. I had to join a little late, so I apologize. Having some technical issues. So on my phone, so I'm trying to zoom in on the screen. But I will just say I feel it's slightly frustrating in this RAC, and I felt this way at the last RAC meeting, where we start to talk about policy and we start to have conversations about how adopting this case law verbatim might not actually, be the best policy to adopt and might have some consequences from it. And I feel like every time we start having that conversation, we kind of push back or get some pushback of just like, well, that's what the case law says, so therefore that's what we have to do. I'm not entirely sure why we would have a RAC if the department is just going to say, okay, well, we have to adopt case law verbatim, especially when we're apparently adopting case law from a LUBA case that was, I'm pretty sure, based on a quasi-judicial application. Like, this is not like the Oregon Supreme Court proffering and going through history of everything. I mean, we're literally talking about codifying a specific LUBA case. And so it's just a little frustrating, I think, to be in this RAC right now, because I don't feel like we're able to have a meaningful policy conversation. And then second, I'll say that I agree with Elaine. I have simply no idea how an applicant is going to be able to meet this burden to show that it's essential to support every single farm use or every single, in the surrounding area. This is a heightened burden that I'm just simply not sure how people are really going to be able to meet as an applicant.
Okay, thank you, Samantha. And so I think there is quite a lot of flexibility as we're looking at how to, interpret these case law provisions and bring them into rule. As we've heard this meeting already, so there's really subtle differences that come from the placement of words, from the way things that are phrased. And our intention really is to do this in such a way that actually helps counties by providing more clarity for this particular one, for the counties that have adopted the legislative language into their code, providing a little bit of additional clarity on what it means to be incidental and subordinate, and on this necessary to support standard. What does that mean? Like, how do you guide an applicant to make sure you're collecting sufficient evidence? I think that's really the intention here. And, so I think that these conversations are really, really helpful. And that's why I'm asking the counties to share a lot about how they work with applicants to, get what they need to support findings that they feel are going to be sufficient to address these standards. And so this is really intended to provide some additional support and clarity to counties and applicants in that process. So, I would encourage you again to, give me a call if there are things that you feel aren't being said in the RAC meetings, or go ahead and provide additional, comments into the record for this.
Hey,
So
Hillary, are you able to see the hands that are raised?
I am not seeing raised hands right now. So can you call on hands, please, Casaria?
Sure. Looks like Mickey was next in line.
All right, great. Thank you.
You have several, Hillary, just to let you know.
Great. I'm not surprised.
I'm going to go back to when you asked the farmers. So I raise sheep and I have chickens, but I don't raise chickens. I have chickens. So for me to say, oh, I'm going to do an event on Easter and charge people to come out and do Easter egg hunting because I have 10 chickens should not qualify. If it just shouldn't. Same with my guard dogs. If I say, oh, I'm going to have an event on, if I was going to have an event and have a dog trial with my border collie, the border collie is a tool in my operation. The border collie is not part of my income. Does this make sense what I'm saying? I just want everybody to realize you need to look at these uses that are going on and what percentage of the farm operation they are. So even if I say I have chickens and I want to do this event, none of my neighbors around me, the biggest stretch would be if somebody's raising wheat and I can say, oh, they're raising wheat and chickens eat wheat in their scratch. That's the big stretch. So I just want everybody to look at when you have farm operations that are doing events, and why it is so important to realize what it takes to do an event and make sure everything lines up with the event, not just because Mickey has 10 chickens. That is not a commercial chicken operation, and that is not, does not, I mean, they don't make any income. Chickens cost money. But they're great chickens, and I inherited them. So I have 10 chickens. So that's my comment.
Great, thank you, Mickey. So what I'm hearing you is that there's a difference between practices and a farm use. So a farm use that is actually a for-profit endeavor on your farm versus, you know, practices such as, so that would be a difference between breeding cattle dogs, you know, versus using a cattle dog, which would be a practice, whereas maybe raising and breeding, training cattle dogs might be a different kind of use. All right, and
got it. That's it.
Okay, thank you, Megan, and then we'll go to Jeff.
Yeah, I'll be quick. I just wanted to offer a different perspective. So in Umatilla County, we do not process a whole lot of event permits. We do get a lot of inquiries for, like, say someone has 20 or 30 head of cattle or a small flower garden, and they want to have wedding venues. So they see this as an avenue to do that. But, you know, our question always is, okay, how do the weddings promote your cattle operation? So I think having the language in there that's on the screen would be really beneficial from our perspective.
Okay, thank you, Megan. Jeff?
Yeah, I just wanted to add, and I'm sorry that our language came in late, so folks haven't seen it, but I think by moving predominant around, we've resolved the issue that Elaine raised about having to go through this crazy analysis if you've got multiple uses. You look at the farm use globally, and it's got to be subordinate to that. And I think by referring to farm use singular, it covers the whatever multiple farm uses there are on that property. So I think we've taken care of some of the things that people are concerned about.
Thank you, Jeff. And I think that ties a little bit into what Mickey was saying too. There's looking at the farm use globally, you know, as a category, and that's defined in 215-203, and that is different than, you know, each individual farm practice, the tools that you employ in your farm operation. I cannot see other raised hands. Casaria, are there other raised hands right now?
Yes, you've got Lauren, then Blair, then Ken.
All right, we'll go Lauren, Blair, and then Ken.
Yeah, thank you. So I'm gonna chime in and say, you know, I agree with a lot of what Sam said. I mean, I guess I don't understand making something clear for the counties that then makes it impossible for anyone to do tourism. That's not beneficial for anyone. I mean, because then it's just, here's the clear language, and then they're left with, oh, I can't approve anything. And no one can meet that standard. And then two, I'm also really concerned about, I mean, and someone brought this up last week, when we're talking about commercial farm uses and what people sell for profit and what they make. There are some things and some agritourism activities that are really important and that are at the heart of a lot of what Oregon really loves. Like I think of a corn maze. They're not selling that corn for profit. And so are we going to just say, we don't want corn mazes in Oregon anymore because that's what the language of these rules are going to have the effect of causing? I mean, and that's where I think it's really important, as Sam pointed out, we need to have the policy conversation about what's the policy for Oregon about what we want to see and how we want to interact with agriculture, and how we want to sustain our agriculture, because It's expensive to be a farmer, and they have to, a lot of our farmers have to supplement to keep their operations open.
Thank you, Lauren. And for this particular exercise, this is a technical, sort of a cleanup of rule language right now. And so this is not intended to be a larger policy conversation about sort of like what constitutes a farm use in Oregon, or, what we desire as a state, to include into that category. So I do want to be clear, that this is a sort of like a technical exercise in tightening up the rules to improve the clarity, because there's been a lot of ambiguity. And this is a sort of topic that's gone to the courts. I think Gordon wants to jump in on what I just said, though. Gordon, and then we'll go to Blair.
Oh, yeah, Hillary, I just wanted to say that, I mean, we do have some, it's not like we're just blindly going to parrot the language from these court cases. Clearly, we already had discussions about how they can be further elucidated, and that's a lot of what the discussion is today. I think where we would have to draw the line is something that basically contradicted or went well beyond what the court cases said, or really kind of went a different direction. That's not the direction we've been given by the commission. And also, if we started doing it that, we might start running into actual, what the statute actually says. We cannot change statutes. That's, I think if there's a fundamental problem here, the problem would be with the statute. The legislature would need to change that. So I just want to bring that up as a point before, and it's just some discussion to what Lauren and Samantha have brought up.
Thank you for that clarification, Gordon. I think that's helpful. Blair.
Hi, thank you. So in terms of these court cases that we're looking at now, it was interesting to hear the county planners talk about exactly what kinds of events and activities they're seeing, the applications under this, and how they decide what the relationship is with the existing farm use. But the courts haven't really addressed that so much. What this language really goes to, and what the court cases that we have addressed, is this relationship between the farm use and the agritourism activity, whatever it is. Meaning the farm use is predominant, even though that language isn't in there. We added that to contrast it with subordinate, which is in the statute, which says it must be subordinate. So it's clarifying how you figure out what's subordinate. And it seems the overall policy is to make sure that the agritourism tail does not wag the farm use dog, right? And I think it was interesting that Mike raised up the winery statute, and I guess the farm statute has this, the farmstead statute. Rather than using incidental and subordinate, they use an actual 75%, 25% standard, which I think people find pretty impossible to enforce or apply. But in any event, it's the same policy. It's like we're talking about getting a little extra income on this farm, but you're still a farmer. You're not becoming a grocer. You're not becoming a restaurant owner. You're not becoming a hotel facility. And you're not becoming primarily an event center. You are a farm. So I think that's, kind of, but it's not really saying what those events can be. So with that, I think this language that Jeff has offered does a fine job of stating what the court cases have said and clarifying it to be clear that the farm use is collective. It's the farm use on the property of the applicant. It's a collective global standard. And it's not just one farm use. That also, I mean, if I were the applicant and I wanted to have a really big activity, if you include all of your farm uses, you can have a bigger farm use because all of your farm uses make it kind of work. I wouldn't be arguing against it if I were on the applicant's side. Thanks.
All right, thank you, Blair. Ken?
Yeah, so I think I've got a couple of quick comments, and I think it sounds like things in writing might be more effective. My first potential question is there's a lot of discussion about farm use, meaning globally 215. And I think that's fine with the definition of farm use. The problem is the rest of the language to me really implies a singular farm use, and the words like predominant use, etc., means a singular use. So one particular thing, growing cherries versus growing cherries and apples versus growing cherries, apples, and lambs, whatever it is. And that to me gets a little bit challenging because farm uses change. And what a particular property is being used at changes. And so when we say existing, it means there's no flexibility. And so that to me is problematic. To Blair's comment, I think there's already protections against becoming a hotel or a grocery or an event center. And so I don't think we really need to think about that. If it gets so unbalanced, I think we know it when we see it. And lastly, to kind of this tension that we're having related to policy discussions, I think what I would say to that is that if we are really here just to codify court language, then we don't need a group like this. And if we're really seeing tensions on policy, then maybe it's absolutely appropriate to go to LCDC and say, hey, we're actually recommending a broader policy discussion about some of these things, including potentially LCDC maybe want to carry bills to the legislature. So I think that we've got a diverse group of folks here with some tension, and maybe having a policy discussion is actually appropriate.
All right, thank you, Jeff. And so I did want to ask you, Jeff, I think that you introduced something new here, and that is, related to this question about that Jeff had proposed about the existing farm use, as opposed to our original language, which was related to the predominant farm use. And I think we've heard that adding the modifier predominant here is too narrow, that it is more beneficial to include the collection of farm uses occurring on the property as a whole, not practices, but the farm uses and sort of commercial endeavors as a whole. And so are there other thoughts about the use of the term sort of existing farm uses, and what that means, particularly for events, which, depending on which opportunity you're pursuing, may or may not happen within a relatively short period of time after a permit is issued. Catherine.
I actually wanted to focus on another aspect of the proposed language. I don't know if that's appropriate to do here now or whether we're still on what we have been talking about.
No, go ahead.
Yep. Okay.
You can come back to that.
Okay, so I'm looking at the incidental and subordinate standard and the essential in order to maintain standards, and thinking they really, and in many ways, they're contrasting standards, in that the first is calling for the proposed agritourism use to be minor relative to the farm use, and the second is calling for the proposed agritourism use to be relatively important to the farm operation. And that poses a kind of conundrum, I think, to county planners, and really requires them to exercise a lot of judgment, and there's a lot of subjectivity involved. With the proposed language that comes from the recent court cases, we've got the new factors that can be considered: nature, intensity, and economic value of the respective uses. That's helpful. But I think because of these contrasting standards that have to be met, if we could be a little more specific about what those actually should entail, I think it would be helpful to county planners. For instance, I think the nature of the two prospective uses, the farm use and the agritourism use, should be fairly easy to describe. Intensity, if we could define that as including, for example, a look at the acreage that's involved, which also tells you how much farm land is going to be taken out of production, the frequency of the activity, the number of people or cars that are involved, and potential other indicators of intensity. That would be good. Looking at economic value of the respective uses, looking at tax returns showing income from both types of uses and certainly other indicators. It's being a little more specific perhaps in this rule might be helpful to counties in toggling these two standards that they have to be looking at.
Okay, thank you. That is a very good point, Catherine. So there is a tension there between, something that's incidental and subordinate and also essential. I thank you for highlighting that. And so what I'm hearing you suggest is that maybe we go a step further and also be a little bit more specific about what sorts of things might be indicative of the intensity of an operation or the economic value of that operation. Can I just ask maybe a couple of planners for their thoughts on how you go about that balance, and then we'll go to Jeff and then to Justin. Like Austin, for example, how do you, if you have an 18 event application, balance that sort of tension between being incidental and subordinate and being essential to the farm uses on the property?
Yeah, so we put that burden of proof on the applicant. I mean, it's up to them to show how your operation, your events necessitate that sort of 18 events or this scale, right? So it's can you really demonstrate that to us? And we don't really get a lot of 18 events. We don't get that much agritourism, honestly, because I believe it's really hard to actually really show all these things and to make it into a successful event. A lot of people kind of don't do it. It's a lot of effort. But it's up to them to really show, how, based on the scale, the amount of people you're bringing in, the longevity of the event, how does it actually work for 18 events, and it's tough. And that's why I go back to explaining to them, well, agritourism needs to be something that would, generally only happen if that farm use is happening. It allows them to frame in their mind, agritourism isn't, it allows them to think about it. Agritourism is not just what's an event I can just do on my land because I have enough land to do it. It's what can I do that actually is a part of my existing farm use and benefits that farm use. Which I find making them think about it like that really helps them. It almost helps them control for what they shouldn't be applying for.
All right, thank you. Thank you, Austin. All right, Jeff.
Yeah, I think Austin hit the nail on the head, and this also partially responds to the comment from the Umatilla County planner. Let's not forget that the agritourism provisions are the fourth in a series of allowed categories of events on farmland. So it's a difficult standard because you're popping up to 18 events. You can certainly do 6 without complying with all these criteria. But if you want to do 18, you better prove it up. And it really isn't supposed to be all that easy. But I think that's what folks should bear in mind, that we're talking about one category of allowable events on farmland. And 18 events of up to 72 hours apiece is a lot of events. It's the open door to a full-time wedding center, which the law is not intended to allow. Thanks.
Yeah, thank you, Jeffrey. And Justin?
I really appreciate Jeffrey's comments there, the contextualization of our discussion. And I raised my hand really just to support what Catherine said about the criteria. I find that very helpful. Factors for intensity include these. They're not ands, they're not, it's more ors. It's kind of, things to consider when doing this analysis. And it would be helpful to get, obviously it would be very helpful to get the planners' input on that because they're going to be ones using it. And if we're talking about a wedding at a cattle operation, maybe there's a requirement that a bull be the ring bearer or something like that. Sorry. couldn't help myself. But thank you.
All right, thank you, Justin. Sorry, I can't see. Do we have more hands raised right now?
You have Jim Johnson.
All right, Jim.
Yeah, I just wanted to say, I was on the original task force that adopted the agritourism rules years back, the one that made a recommendation to the legislature, and it's and when we discussed this, it really fit right into what Jeff Kleinman just said. The large events operations were supposed to be more difficult to approve because of the potential for greater impact and for the potential for greater abuse. If you wanted to do a single event or the 6 events or whatever, it was going to be a lesser standard, and that was really the approach that the task force took, that was when it was sent to the legislature and ultimately was adopted. So I just wanted to say Jeff Kleinman hit that one right on the head.
Thank you. So it does sound like a lot of the conversation has moved, to concerns around the sort of necessary to support standard, and the sort of guidance from the court that the events be essential to the continuation of farm uses on the property, or essential to other agricultural enterprises in the general area. So are there any other thoughts or comments on the necessary to support standard? I don't think we've heard from Rory.
Rob has his hand up.
Okay, Rob. Great.
Hi,
Thank you.
thanks. I actually wanted to move backwards in the conversation a little bit.
Okay.
Sorry about that, but it is still related to that or both criteria. And I think we're getting bogged down in confusing farm use with crops. I mean, I heard some comments about crop rotations and changing crops. Well, that might be true, but this doesn't say that it's subordinate to individual crops, that it's subordinate to the farm use. And if there's some way that we can word this, I don't have a suggestion in mind right now. I'll think about it, but to make it clear so that future generations of county planners understand that we're not necessarily addressing the current farm mix. Well, it might be the current farm mix at the time they apply, but it might be different in some future year, but it might different crops, but it's still the predominant farm use. Hope
Thank
that
you.
makes sense.
Yeah, so I think that, Rob, I'm hearing you're referencing back to one of the things that we had a discussion about earlier, which was Ken's concern about some language that was introduced by Jeff Kleinman that referred to the existing farm use.
Well, and others had expressed the same concern.
Yeah.
That we have to go crop by crop and determine which one is the predominant crop. And I would contend that the only way to look at this is more universally for the entire farm operation, that trying to break it down crop by crop or commodity by commodity would actually be inappropriate, that it would just be looking at the overall farm operation.
Yeah, thank you. So again, language.
But I don't think it's obvious the way it's worded right now.
Okay. So yeah, I've definitely heard a number of times that when counties are looking at determining that a proposed event is incidental and subordinate, that test should be measured against farm use of that property as a whole. We're hearing, I think we have some work to do on the language to make sure that it reflects sort of that concept, rather than a single farm use or an evaluation of farm use by farm use being conducted on the property. All right. Are there other hands up, Casaria, right now? No. Okay.
No, that was it.
Yeah. Any other comments or questions on the necessary to support standards? So we've heard from Jim and from Jeff and others is that the 18 event per year opportunity was, meant to be more difficult. So it does have that additional standard associated with it. The necessary to support standard, which is a rigorous one. And it sounded like that some of Elaine's original concerns were really targeted towards that standard and the evidence necessarily to demonstrate that standard is met. And we also heard some suggestions that maybe we consider including some language that is indicative of what types of things could be looked at in provision of evidence to demonstrate that that essential standard has been met. Mike, did you have some thoughts on that?
Well, Catherine Daniels stated a little bit earlier about the sort of the conflict between incidental and subordinate and necessary to support. And that was my thought early on. It means, probably rightfully so, that there's a fairly narrow range of which it qualifies for the 18. And I think that's a good thing as a farmer, that I think that's very important, that there's a small range. The only thing is, I'm not sure we're defining that range well enough in either A or B.
And do you have ideas on what we could do to improve the definition of that range, Mike? Yeah.
I would have to spend a little time trying to reword that. And
okay.
Not at this moment. Thank you.
All right. Thank you. Austin.
Yeah, and in response to this, I don't have a great suggestion on how to nail down that range right now, but I kind of look at it as the same way as primary or secondary farm dwellings, I should say, not primary. But when we're doing secondary farm dwellings, you know, it doesn't read that there's a limit per application of secondary farm dwellings. You can apply for 1, you can apply for 5, or you can do multi-unit, you know, housing for a lot of people. But it is up to you to show how your operation actually necessitates that. So it's like if you come in and you've got 5 acres of land and you need 20 units of farm housing, we're going to say no, that you prove to us how that works. The same thing with agritourism, you know, it's really show us and have thought through this proposal and think about how it really actually, you know, is playing a role in the farm use, and does it raise to the level of 18 or not? So that's just some good context, I think, to help think about it in a way that we think about other land use applications.
Right. Thank you, Asta. That's very helpful feedback. So, yep, as we know, the burden of proof is on the applicant to provide that demonstration. Are there other thoughts on how that can happen? Let's see. Elaine?
Just a quick clarification.
Mm-hmm.
You were quoting the case, and I think Charles quoted it too. Which one are you referencing? Is that the?
That is from 2019.
But which case? Sorry.
The D. Benedetti.
The Benedetti, the 2019.
Yeah. Thanks. Yeah. All right. So folks that we haven't heard from today, Nellie, Rory, Jan, additional thoughts on the topic?
Yeah, thanks, Hillary. This is Rory. Been tracking along with this kind of debate about whether we're talking about a single farm use or activity or global. And I thought about suggesting, well, why don't we say existing farm uses on the tract? But I think the clarification about, you know, we're referencing the definition of farm use at ORS 215203, which is inclusive of all the various farm uses, that kind of covers that. So to me, the concern about what we're comparing against when there's multiple farm uses on a tract, I think it won't play out to work that way, because the term farm use is a legal term of art all the farm uses. So that was my only thought, but I don't think we even need to go there with everything else folks have been saying. So yeah, and I guess, you know, since I have the floor, I do like Jeff's language that was up a while ago. I think it deals with it a little more artfully. Thanks.
Okay. Thank you. Casaria, are there other hands raised right now?
There are not.
Okay, great. So any other thoughts from folks on this particular question? Or on the existing addition of the word existing farm uses? Does that preclude, you know, changes in the farm use going forward into the future? Or What are there additional thoughts or concerns about that language? All right.
Hillary, Jeff raised his hand.
All right, Jeff.
Yeah, I think that's a legitimate concern that Ken raised, that the farm uses may change over time and still be farm uses. So I think we can look at that a little bit more. I don't have a specific suggestion right now.
Okay.
Austin has his hand up, Hillary.
And Austin?
Yeah, I guess again, my one other thing to add to that is I see where that could be. I can see conflicts on either end where you've got an approved agritourism permit under existing farm use and your farm use has changed. Then well, do I have to submit again? But I think from a county planning perspective, we would say if you're going to like substantially change your farm use, right? Let's say you're going from we've got a big Iris festival that happens every year down here. That's a very specific use. That's very different from horse racing, right? And barrel racing. So let's say you're approved for this flower festival, and then you change and you sell your farm and it goes to horse racing. You change to horse racing. Well, should you be allowed to do the horse agritourism under the same one you got the approval for the flower festival for? So I think it's, if you want to put existing in there and it substantially changes, is that agritourism permit actually going to cover that substantial change in farm use down the road? Is something that I would think about. That's just a downstream effect that I could see of that language addition, or however the rule gets written.
And then it really becomes an enforcement issue rather than a land use permitting issue. And the burden for that is really borne by the county.
Yeah. And I would say it's easy enough to apply for a horse-related agritourism permit apart from a flower-related agritourism permit. If you're still meeting the standards, you can still meet the standards and get it done. But that's something I see in the implementation portion.
Okay. And is that an enforcement issue that Marion County has needed to address over time?
Not yet. We haven't had anyone's change like that. What the enforcement issue is someone applying for agritourism and the event is really not what they said on paper, or it grows into something different. That's normally our enforcement issues.
Okay. So when the event grows beyond what was actually permitted and the conditions of approval associated with that. Yeah. Okay. Rory?
Yeah, just the conversation about farm uses changing over time. It's worth remembering that subpart 5 of the statute requires a holder of a permit authorized for up to 18 events per year to reapply essentially every 4 years. So whether that's the right time period or whether it should be for other permit holders with less than 18 events under A through C, it's kind of, I guess, maybe irrelevant because the statute says that it's a 4-year interval and only for that up to 18 events.
Right. So for the 18 events, does the 4-year sort of renewal requirement, or for the 6 events is the 2 years re-permitting requirement, like actually allay that concern that there might be a significant change in farm use that the events are meant to be related to? Thank you for that, Rory. Blair and then Jan.
Thank you. I would just follow up on what Austin was saying, that when the way the statute's worded and when an applicant comes in for an agritourism events permit, the permit is related to the existing farm use. It's not, if they're planning a future farm use, it's premature to get the agritourism permit. The farm use has to be established and then come in. So I think to sort of say any future farm use will create a very difficult situation to manage. And I think that the intent's pretty clear. It's an existing farm use.
And so what I'm hearing, Blair, is that we don't want to be in the position of issuing agritourism permits for non-existent farm uses. something that doesn't exist right now.
Exactly.
And yeah, okay.
Exactly. And as the planners have stated and others familiar with the workings of the statute, the landowner, if they do change their farm use, they can come in and apply for a permit related to a different farm use at a different time.
Okay. And Jan.
Yes, I agree with what Blair just said, so I don't need to repeat it.
All right, thank you. Okay. Kasaria, are there other hands up that I'm not seeing?
There are not.
Okay. And so maybe could I just ask the planners to come back to the idea that Catherine introduced about, should there be additional clarity on the sorts of metrics that are associated with nature intensity and economic value? Are the addition of those sort of categories, those broad categories, helpful in providing clarity, or would additional sort of language around metrics to be considered, like acreage and number of cars or something along those lines, be additionally helpful? Or would it be overly limiting? I'd love some planner feedback on that particular question. So can I pick on Matry? You guys have a wide variety of sort of very specific standards.
Yeah, thank you. I was actually thinking about that. It's a challenge. We don't have the agritourism as such, granted, but it's a challenge we face often. If I were to pick on an example like the farm stand, then I mean the size of events they propose is like sometimes it's humongous. Like right now, I'm reviewing a farm stand application, and they are proposing a farm stand, but the number of events they're proposing with it, and then saying that we're going to stay within the 25%. We insist that you include a condition to that effect. That kind of, it would really help if there was some kind of guidance on how much, if there was some clear and objective, maybe guidance, like you mentioned. I wouldn't know how to pinpoint the number of cars, but or the number of people, but yes, those would be like ideal circumstances where we have actually a rubric to follow, and you cannot go beyond this. Something to that effect would be very, very helpful.
Thank you. And for the smaller events, there are some limitations on people and vehicle and hours of operation. And many counties have some additional standards that they've added into their codes. And so I think when we're asking about this, we're really talking about the 6 and 18 event questions, and particularly the 18 events. Catherine, but did you want to clarify what you actually meant there?
Yes, I just want to clarify that I'm not necessarily proposing the specific limits be introduced into the language, but that specific criteria be considered, such as the acreage, the number of people in cars, and the frequency of events. I would think that would be helpful, and then it would be up to the counties if they chose to introduce specific limits. That was my thought.
Thank you. Elaine and then Mike.
Thanks. Just a quick question to understand, folks, where people are coming from. There's 6 counties on the rack, is that right?
There are.
Okay, and then how many of those counties, I think you guys, some of the planning directors talked about at the beginning, but I missed tracking. How many of the counties who are participating have actually implemented or allow the CUP agritourism on the rack? So just when we're getting people's perspectives, it'd be helpful to know which counties do not allow agritourism as CUPs that they've opted not to implement.
Quick raise of hands. I think Marion County allows them. Umatilla allows them. Lynn has not adopted them. Washington has not adopted them. Amber? Does Lane?
Lane County does allow
We allow up to 6 events and the option for up to 18 events through a type 2 permit.
Okay, thank you.
And Charles, you said Jackson does not have the provisions, right? Okay.
That's right.
Thanks.
Hillary, Mike has his hand up.
All right, Mike.
Yeah, one thing in the criteria around incidental and subordinate, one thing that might be helpful would be employees or payroll. We have economic value in there, but certainly employees is very indicative of the intensity of the farm use versus agritourism uses.
So far we've heard things like acreage devoted to the relative uses, the potentially number of cars, employees, payroll. What was the other thing other than acreage? Any other thoughts or ideas on that particular question? Okay. So we're kind of getting close to an hour and a half on this conversation. So I just want to wrap up. So we've had a lot of conversation about making sure that when we're comparing the proposal to farm use, that we're including farm use as a broad category, that what we're really talking about, we've clarified, are farm uses under 215-203 and not farm practices individually. We've had some questions about whether, we're looking at the existing farm uses at a moment in time on the property, or whether there's some flexibility for that to change over time. And as Rory noted, there are review triggers depending on which application you've sought. That may or may not make that necessary. And then we've had some discussion about maybe fleshing out the types of things which may also be considered in these reviews. Are there any other questions or concerns? Now, before we move on to a break in our next topic, I want to make sure that we have carefully heard everyone. I think a concern that we've heard is not making it so difficult or changing the standard in such a drastic way that it would preclude event application permits. But any other thoughts or topics that folks want to introduce into the conversation at this point? Anybody that we haven't heard from yet want to, add some final thoughts into the conversation? Well, Charles, will go to you, and then anyone else who wants to close.
Would you mind putting up the proposed language again?
Yeah.
So people can see that.
Sure.
Is there any concern with the second paragraph that the way it's worded, that it says a determination that an event or activity is necessary to support either the farm uses on the farm or commercial agricultural enterprises in the area? Is that adding some confusion as where the necessary to where the event is taking place, I guess?
Mm-hmm. So what do you folks think? Does that add any confusion? I see that people have raised hands, but I can't see who has raised a hand.
It was me.
Austin?
Yeah, I can see how that would definitely raise confusion because that reads that you can either do 18 events on your farm that has X type of farm use, or you can say, well, in the Willamette Valley or Marion County, the general enterprises in the area, this this agritourism event would benefit those, which sort of opens it up to someone maybe not having any farm uses at all, doing a large event on property. It's under the saying that it's under the agriculture enterprises in the area, which I'm not sure a lot of the counties want to get into. That's sort of what agritourism I think is not supposed to be. If you don't already have a farm use, doing agritourism is generally not something you're supposed to do. So I think that does raise some concerns for me, and I imagine potentially other county planners too, or just other people in the RAC.
Okay. So we feel that this language introduced some uncertainty as to like where these events are being authorized.
Let me see what our code says right now. I wonder.
And so folks know that that's statutory language is, essentially states that the events are incidental and subordinate to existing commercial farm use of the tract and are necessary to support the commercial farm uses or the commercial agricultural enterprises in the area. So that's coming directly from statute.
Okay.
I thought it was clear in the statute, but I thought the way it was worded in this OAR was different, a little bit different, but.
Okay. So maybe we need to work on the language there to simply to clarify that.
And yeah, people can look at the stuff that I wrote, as a suggested clarification on that, and we don't have to talk about it here, but you can look at that.
Okay. All right. Thank you for flagging that, Charles.
Yeah, so our code says, in every section that it must be incidental and subordinate to the existing farm use on the tract. So, our code sort of controls already for that. But yeah, I can share the same concern as Charles, in that it does sort of seem to right there just make it sound like if you're just in the agriculture area, you can do it. But that's about the only thing I read on there that I have an issue with.
Yeah, if I may, real quick, I think it's the or is the questioning component. It's if it was and maybe that's the clarification.
Yeah, I agree.
Yeah, but if you want an and, then you have to prove both.
Yeah. Yeah. Jen, you had your hand up?
Yeah, I just wanted to amplify what you said, Hillary. This is the statute, so that is the language in the statute. But remember, agritourism is enabled but not required by the county, so they can be more restrictive. So what Marion County has done is made it a little more restrictive or more focused. And I think because it is optional for the counties, they have the ability to do that.
That's a very good point, Tim. Thank you. All right, we'll take an additional look at that. All right, before we move to break, any other final thoughts or concerns, especially folks who haven't had an opportunity? Rory?
Yeah, so there's a couple other uses that are outside the scope of what we're talking about today, but that use language that's very similar but not identical to incidental and subordinate. And I kind of just wanted to flag that for the whole RAC. The two uses that I'm referring to, I think it's just these two, are equine therapy centers and guest ranches. And in the second De Benedetti case, the 2020 case, the court discussed some of those other uses in its discussion of what a dictionary definition, what is the meaning of incidental and subordinate. They referenced other uses that use similar language, but not but don't use the word subordinate. And we've had here in Central Oregon, a county hearings officer in reviewing a guest ranch application referenced this language and the De Benedetti case with approval, saying, well, this should be the test for these other types of uses that don't use the exact phrase incidental and insubordinate, but we're going to assume the legislature intended the same analysis. So, it'd be a can of worms and outside of our scope to debate the language of those two uses. But I've been thinking about it, and I just thought I would flag it for the whole rack that there's a chance, I'd say a pretty good chance, that this language that we're developing today could be sort of parroted and used in an analysis of other uses that, for whatever reason, use slightly different language.
Thank you, Rory. So, as pointed out in that case, it's, incidental is definitely a term of art in planning, right? And it's used throughout county codes, not just in exclusive farm use zone statutes. So it's often used with other accessory type uses in other zones. And, there are a handful of counties that have the word incidental defined in their code as well. I don't know if any of the counties here do. And we do need to be very clear that our charge and what we're doing today is very specific to 215, 213, 11, and 215, 283, 4. So the way that we've structured it is to be very clear in the rule that that particular expansion on that definition is for the uses that are authorized under those sections of statute. All right. Any other last thoughts? Nope. Okay. So this has been a great conversation, folks. I'm just so pleased with the amount of information and feedback that we're getting from our advisory committee. And again, if there are thoughts on this topic, please send them in writing to me, and we will, get those out in the next packet that's sent around. It's very helpful to have it in writing as well. These sort of suggestions and thoughts from you guys. And again, if you didn't feel comfortable sharing your thoughts or opinions today, that's a great way to do it, is send me a note. So I'm going to set a timer for 5 minutes, and suggest folks might take a little bit of a stretch or a water break. And then when we come back, we're going to be talking about rural transportation uses on when they happen on land that's protected under Farm and Forest Conservation Program. All right, so we'll be back in just a few moments. All right. Let's see. I think our 5 minutes are up. And we got most folks back now. We will wait until a few more folks get back. All right, so hopefully everyone is able to take a bit of a refreshing break. And we'll move into the second half of our conversation. So again, we're going to be talking about rural transportation improvements when they are located on lands that have been protected under the farm and forest conservation programs. And then we're going to leave a little bit of extra time at the end today to talk about the LCDC meeting later this week and potential additions to our Rulemaking Advisory Committee charge. Okay. So I'm going to start off talking a little bit about some of the legislative and rulemaking history behind 660-1265. And I suspect that there are some folks on this rack who were around during that process, and I might ask you guys to share any thoughts or observations about what happened back in that time. All right. So when we are talking about transportation uses that are permissible on farmland, there are essentially 3 places that you find those uses listed. And it's important to remember a little bit about the construction of exclusive farm use zones for this conversation. So for exclusive farm use zones, only farm use and those uses listed by the legislature in Chapter 215 are permissible. And that list that was established by the legislature is divided into 2 buckets: uses that the legislature determined to be compatible for farm use subject to standards. Those are type 1 uses. And for transportation uses, there are a number of uses listed under 215-213 sub 1, 215-283 sub 1. And then there's a second bucket of uses established by the legislature, which require findings under the farm impact test. And these are sub 2 uses or type 2 uses. And so for transportation uses, there are a number of things about like roads and highways and other things that are listed in 215-213 sub 2 and 215-283 sub 2. We find there's a third bucket for transportation uses. These are uses that are identified by LCDC in rule. And the legislative authorization for that rulemaking is in ORS 215-213 sub 10 and 215-283 sub 3. And that's the other allowable transportation uses. So there are the type 1 and type 2 uses, and then the Division 12 list and rule that we believe is subject to the farm impacts test, and the Division 12 list and rule that is clearly subject to the farm impacts test, and some additional criteria in 660-1265 sub 5, which we'll call the super farm impacts test. So really quickly, these are the type 1 transportation uses that are very clearly listed as type 1, and I'm including the forest rules here as well. So everything in forest zones is actually in our rules. So climbing and passing lanes, reconstruction and modification of public roads and highways, temporary public road and highway detours, minor betterments, and then in forest zones, there's another type 1 use, which is a widening of roads within existing right-of-ways, but that's in Division 6 only. So then these are the type 2 uses that require very clearly findings under the farm impacts test, and that's construction of additional passing and travel lanes that require more right-of-way, reconstruction and modification of public roads and highways involving displacement of buildings, improvement of public road and highway facilities like maintenance yards and way stations and rest areas. All right, so then we get to this third sort of category of transportation uses. And that's the important to this conversation. That's the legislative authorization for a third bucket of transportation uses identified by LCDC. So what the legislature said is that roads, highways, and other transportation facilities and improvements not allowed under subsections 1 or 2 of the section. In that case, they refer to 215.213 sub 1, 215.213 sub 2, or 215.283 sub 1, and 215.283 sub 2. May be established subject to the approval of the governing body or its designee in areas zoned for exclusive farm use, subject to either an exception under Goal 2 or 215.296, the farm impacts test for those uses identified by rule of the Land Conservation and Development Commission as provided in Section 3, Chapter 529, Oregon Law, 1993. So what that refers to is Senate Bill 1057 that was enacted in 1993. And that bill evolved from a concept proposed by the Oregon Department of Transportation as a result of a Linn County court decision. And that concept that ODOT proposed at that time primarily revolved around allowing road rear alignments as a conditional use in farm zones. So there wasn't enough time in the 1993 legislative session to formalize the language that was discussed. So the compromise was to authorize rulemaking to identify transportation uses and improvements with minor impact that could be allowed in exclusive farm use zones, subject to findings under the farm impacts test. So as a result of that, Senate Bill 1057 in 1993, a rulemaking was undertaken, and the initial advisory group was actually convened and facilitated by the Department of Transportation, and then which then proposed rules to the DLCD. And following a mediation process and some other stuff, the rules were eventually adopted by LCDC in 1995. So that 1995 rulemaking restructured 660, 1265 into what it looks like today. So here's the basic list that came out of that process. There's a clarification that's actually not here that the uses on this list are consistent with goals 3, 4, 11, and 14. And then anything in bold here on this list, on this slide, is also subject to 215.296, the farm impacts test plus criteria, additional criteria that are listed in 660, 1265, sub 5. And in the rulemaking record, those criteria are referred to as the 296 plus criteria. So this is how it is structured right now. So there is some ambiguity into whether sort of the non-bold items on this list are subject to 215.296 farm impacts test or not. And the department has taken, a position for quite a number of years that the legislative history, the rulemaking history, and the language in the authorizing statute that we just looked at is very clear that the purpose of Division 12 list was to identify transportation uses with minor impacts that could be reviewed subject to the farm impacts test rather than through the more onerous and lengthy exceptions process, which is what ODOT's concern was at that time, as I understand it. However, there's been confusion on this point because the adopted rules in Division 12 don't clearly state that these listed uses are subject to findings under 215.296 when resource lands are implicated. So Division 12 applies to rural transportation uses in general, and it doesn't clarify what happens when those rural transportation uses are on lands protected under farm and forest zoning rather than in exception areas. So We have a guidance document specific to one of these uses, the trails use that we provided to the Rules Advisory Committee, sort of as some background on the agency's interpretation over time. The recent Yamhalis West Sider Trail case supported our rule interpretation, and thought it is time to clarify this in the Division 12 rules. So what we have proposed is adding a section in 660-1265, clarifying that for the uses listed, unless they are already listed in as a sub 1 use in 215-213 sub 1 or 215-283 sub 1, which are not subject to the farm impacts test, that they are indeed subject to the farm impacts test. And we are also proposing a clarification here that for forest zones, that they are subject to I'll call it the forest impacts test, which is substantially similar to the farm impacts test, but it also requires an evaluation of whether the proposed use will increase fire risk or the cost of providing prior protection services. Okay. So again, I think there may be some people here. I mean, Rob, were you around when this was being discussed in the 94 and 95 rulemaking? Not sure how far back you go. Or Jim?
I don't go back that far with this.
Okay.
I'm sorry.
Yeah, unfortunately, I do go back that far. But basically what you have described, Hillary, is what's what was the thinking there. I mean, ultimately, the discussion that I remember, that I recall, and it's, even though I was around, that's been a ways back now, was these are non-farm uses, and thus they should be subject to some kind of review, not through the exceptions process. Conversion wasn't the issue, or they didn't want to make conversion the issue. What the issue remained was impacts to surrounding farm and forest operations. And so that's why the farm impacts test would still be employed. But there wouldn't be, like when you go through the exceptions process, that that look at alternative locations, that conversion issue. It's all about compatibility with surrounding farming and forest operations. And remember, 215-296 talks about mitigation, so it's not always just a yes or no, it can be a how also.
Right, very good point. And Catherine, you also had a hand, I believe, in crafting that guidance document. Do you have some thoughts or feelings on this particular topic you want to share?
Yes, this was an issue that got a lot of attention and interest on the part of counties while I was most recently a DLCD from 2008 to 2016. And I came to the conclusion, and the agency came to the conclusion, that the intent of statute was that the unbolded uses denoted in the rule, the transportation rule, be subject to the farm impacts test and the forest impacts test as well. And that was the interpretation we communicated to the counties. And so I think that this is a good idea to put this into rule.
Okay. Thank you. And so for counties out there, maybe Maitri or Amber, are there, how do you view this language in this list? How have you adopted it into your code, and how has it been working for you?
Well, I'm sorry to say that I was looking through our permit records, and I don't believe we have, I couldn't find any particular, at least I was focusing on recreational trails. But we've largely permitted those in public parks. I couldn't find any great examples on this that would be helpful. So I apologize.
No problem. Thank you. Matri?
Yeah, so we don't see too many of these either. And the only one I too can talk about are really trails. And the public trails are generally, we'll handle them as public parks, but private trails not so much. I mean, they've been proposed, maybe small ones on a single property as in conjunction with maybe a zip line park or maybe with a campground. So mainly it's been just through the parks standards that we've approved them.
Good. Thank you. Jim, you have your hand up?
Yeah, just the only other trail that I can think of where this came up was a proposed trail between Corvallis and Albany, and they wanted to run the trail out through farmland adjacent to a railroad right of way. By Benton County really got into a discussion of this, and they, in a sense, had a farm impacts test discussion. And after that discussion, the trail was actually moved over into the right of way of the highway instead of the railroad right of way, which cut through the middle of a lot of farms and the like. And that's the farmers ultimately that I discussed this with felt that the process worked because, in effect, the impacts to surrounding farms were taken into account. And instead of going at that location, they moved it. They moved it over into the road right of way adjacent to the state highway there. The only other situations where I've seen something on these lists come up have been pipelines, but they were energy related pipelines, and so they went through the Energy Facility Siting Council's process and not this, and so that was a little bit different. So that's been the extent of these smaller transportation related uses. Usually they're the other uses that are listed in the rule that I've been involved with. So
okay, thank you. So more experience with trails and pipelines, maybe not so much some of the other facilities. Let's see, who else has their hand raised? I can't quite see that.
Mickey does.
Mickey.
So, good news. There are 2 on the ground and they are drinking milk. A boy and a girl, and they're healthy. But while I'm pulling my hands up, is I sat on a county-wide trail thing that they wanted to go from Madras to Metolius to Culver. And ODOT basically came in and said, and they've been applying for grant and they didn't make the cut, saying that you got to do it in the right of way. We're not going to fight the farmers. I'm on there as representing the farmers, but so that's what ODOT told the group. And they had to figure out how to do it, and it had to be on county and state right away. And that we've been working on that for 2 years. So I just thought I'd share that bit of information with you.
Thank you. So it sounds like there must have been quite a few concerns articulated by the agricultural community relative to that proposal.
I guess statewide. I mean, ODOT basically came into the first meeting and said, we're not going anywhere unless it's on county or state right away. We're just not going to deal with it because it would have impacted a lot of farms. And that was just what they said to start with. So that was where the group started.
Right. Thank you, Mickey. Jim?
I just wanted to add to Mickey's comment there. Historically, my experience, any linear facility through farmland really brings the agricultural community out with concerns because it introduces the public into an otherwise industrial landscape. So I'm not to say that some of these can't be compatible, but there needs to be that review because you are, in a sense, creating a new public avenue through a working landscape that uses a lot of practices that aren't necessarily conducive to recreational use. So,
thank you.
Amber also has her hand raised.
Amber.
Thank you. So I just wanted to circle back. I'm doing a quick comparison in our code, and will admit I don't recall completely whether this came out of the model code. We updated our farm and forest zones in about 2018 using VLCD's model code, and a number of these uses are listed as conditional uses, and we apply the farm impacts test or the forest impacts test. So I'd be happy to take a closer look at that and do a more detailed cross comparison, but it does look like a number of them we have listed in our code as a conditional use.
As conditional uses. That's good to know. Thank you for that feedback. Charles, how do you approach transportation facility proposals that are on the Division 12 list, or have you had many of these types of applications?
We don't get a lot of these types of applications, especially when I was looking at the trail ones. We had a master plan for a public park that went to the standards there, and then actually it was a goal exception. I believe we cover that you have the farm impacts test, I think, for those types of uses. So I guess there wasn't any. I think the recommended changes make sense that you've proposed. So
thank you. Does anybody have any thoughts or questions or concerns about clarifying that the forest impacts test essentially applies to transportation facilities in forest zones? I will share personally, when I was at Tillamook County working on a road realignment, it was a little confusing. And we sought support from DLCD on that interpretation. No. Jim?
Yeah, Hillary, I would just say that I have gotten some calls related to the Salmonberry Trail that would start in Washington County and go through to Tillamook County, and from a couple of landowners who were farmers who also owned forest land. And they asked me on their forest land properties what would be the process for that and the like. And I really did not have an answer for them because wasn't clear. In fact, I probably passed them off onto you guys, but that issue does come up, and a lot of farm operators do own forest land also. So,
okay. So it is a little odd, and I think definitely an area that merits clarification. So the language in 666.25.4, which are conditional uses in forest land, essentially everything in 25 sub 4 are subject to the forest impacts test. And the language in that section of the rule refers to this provision in statute. So that may be a little complicated. I thought about drawing a graph or some sort of graphic showing how they all connect, but so we were feeling comfortable about that. I think that clarification would be helpful. Maitri, did you have thoughts on that? I noticed you unmuted.
Well, we did have them come in for a meeting, but we haven't really seen any, nothing's really come in for review yet, but it's just a little challenging with that one because it doesn't really cut through different properties. It's kind of on the railroad right away. And it just goes through all of the different zonings you can possibly think of in the rural districts. And we kind of tried to break it up and talk to them about the different standards that would apply specific to those districts for each segment that goes through. And an impact analysis for sure. And then there was a lot of discussion too about some of the issues. When we were working on the Banks of Vernonia Trail, a lot of issues had come up where people had questions about trespassing onto farmers' properties, their safety, and all of that. So those topics were also raised at that time.
All right, thank you.
Yeah.
Any other thoughts from folks on this particular topic or concerns about this? Joy, is this something that your agency would be concerned about or have questions about?
I don't have any questions right now. I think I'm just kind of digesting all of the information and conversation. Yeah, but thank you for checking in.
Okay. So why don't we wrap up with that? And if folks do have concerns about this particular amendment, please go ahead and send them to me, or give me a phone call. If there are other alternatives or suggestions, which I'm not hearing today, unless somebody wants to raise their hand. I don't think I'm missing any raised hands right now. No. Then go ahead and reach out to me so we can make sure and address those concerns in this language. So otherwise, any other last thoughts before we move on to sort of next steps in the meeting coming up? Nope. Okay. So I do want to let folks know and answer any questions about next steps. So there is a commission meeting this week. And one of the agenda items on Thursday for commission is adding to the scope, adding to the charge for this particular rulemaking. So back in March, when we did sort of our initial check-ins with the folks, we alerted that there might be a possibility that the commission will add to the scope of this RAC. I would encourage folks to sort of take a look at the materials that are being submitted to commission for the farm and forest agenda item. So part of it is talking about a multi-year work plan that the agency is engaging in, looking at technical improvements to the program. And that includes a variety of things, from white papers and guidance documents, public outreach and education, to additional rulemaking proposals. But also in that same agenda item, there is going to be a request to the commission to add to the rulemaking charge that will impact this group. The intention is to keep this RAC for consideration of those additional items. There are 5 items that are being proposed to be added to the charge for this RAC. So the first one involves sort of providing some additional guidance around the evidentiary standard for verification of income. So this is something that we heard in our technical working group. This is something that we heard as a need or a desire from a lot of counties, that they would like some guidance on sort of the sufficiency of the evidence when you're looking at income standard for dwellings or for farm stands, for example. The second item that we're going to be talking to the commission about is repairing a circular definition of preparation in our rules, and adding a definition of processing in our rules. So the way that our rules are structured right now, preparation is, part of the definition of farm use, and the way that preparation is defined in our rules, essentially is circular, saying that, preparation of farm products can happen anywhere that farm use is happening, and since preparation is farm use, it's totally circular. And we'll look at adding a definition of processing, which is another thing that has come up quite a lot in the past several years. And we'll be starting with likely, if the commission chooses to add these items to the charge, we'd be starting with a Department of Agriculture definition of processing. The third item we will be talking about, or we'll be asking the commission to consider on Thursday, is a refinement to the template test language. So when you're doing a template test, you can either use a square, or under certain circumstances, you can use a rectangle. And when you are in a circumstance that allows you to use a rectangle, that rectangle has to be aligned to the maximum extent possible with a stream or a road. And we've received a lot of requests for clarification on how that should be accomplished and what does it mean to align that rectangle with a stream or a road. Streams and roads are not always linear features, and sometimes they can be quite convoluted. So we may be looking at that as well. And then another item is looking at what constitutes a recreational use for a private park, based on some case law that came out around that particular topic. And then finally, we're looking at the question of if something is already listed in Chapter 215 as a use subject to standards, whether or not it may be alternatively permitted as a home occupation or a commercial activity in conjunction with farm use, unless the legislature has already specifically authorized that. So those are sort of the 5 topics that we'll be talking to Commission about on Thursday, and that we may potentially be adding to the charge for this Rulemaking Advisory Committee. So I wanted to make sure that if folks had any questions or concerns about adding to the scope of this charge, that we'd be able to hear them. You're welcome to give me a call. Hopefully everyone had a heads up about that in March, that we might be expanding this Rulemaking Advisory Committee's charge. And if the Commission does, then we would be meeting in May and in June and in July. So every month, to make sure that there was time on the schedule to consider those additional topics. So any questions about that particular portion of the next steps or the Commission meeting on Thursday? And again, you're welcome to provide testimony to the Commission on Thursday. I can circulate a link to the Commission's sort of website and webpage where you can sign up to provide testimony. I know some folks already have. So any questions about that?
This Elaine, no questions, but I will comment. It's a huge undertaking for the RAC. And I think that each of the items you identified as potential expansion areas could almost in themselves warrant a RAC, or maybe, coupling a few of them. But I just think that that's not all the right people may be at this table to have a more robust discussion on what ultimately will be some pretty significant potential changes to the existing rules.
Thank you. Gordon?
Hillary, I think that Elaine and others, if anyone does have a suggestion to reach out for additional members for the RAC to represent interests that are not here, we would welcome any suggestions on that. And you are correct, this some of these topics could be fairly complicated and controversial when we delve into them, and we'll see how it goes when we do that.
Yeah. Thank you. All right, so if there are any additional questions or concerns about that, please feel free to go ahead and reach out to us and communicate those. And as Gordon noted, like if you have suggestions for folks who, if the Commission authorizes us to move forward with some of these additional topics, suggestions for folks who should be included in the ghost conversations, we would love to hear that. Otherwise, again, we will continue to meet monthly through July. At the May and June meetings, and July, we'll be asking our RAC members to review suggested language, needed edits. In July, we'll look at the final proposed language and also the fiscal impact statement. So otherwise, Catherine, you had a comment?
Yes, I wondered if we could get a query as to when the best meeting dates are as soon as possible for the next couple of months?
Yeah, I am also that's a very good point. I'm also very anxious to get my schedule nailed out for the next couple of months as well before it gets too much fuller. So yeah, as soon as the meeting concludes, the next day, Friday, we can expect some doodle polls, and assuming that the commission asks us to move forward with expanding the charge, whatever that looks like. All right. And I will go ahead and send out just the link to the commission page for everyone, so you know where to find that material and the opportunity to sign up really easily. Okay. So anything else? We did finish a little bit early today. Before I just move on to sort of final few wrap up points, which is great. So again, encourage folks to submit any additional comments, language revisions, thoughts to me in writing. I will get meeting notes out for you to review. Go ahead and provide any comments. Hopefully, I would ask you to provide those sort of comments within a week and a half to 2 weeks of getting the meeting notes out, just in anticipation that we'd have a May meeting and that those comments would be received in time to include them in the May meeting packet. That packet for the May meeting will hopefully be posted at least a week in advance of that meeting, ideally 2 weeks in advance, but we'll see what works with one, whether the commission approves in addition to the charge, and two, when folks' availability looks like for the May meeting. Otherwise, thank you all so very much for volunteering your time to serve on the RAC. I know you guys are all very, very busy. Your time is a gift, and I am super appreciative of the amount of material and written comment that the advisory committee has provided for us in this. We've gotten a lot of feedback, and it's really helpful and very constructive. So thank you all very much.